Mr. Texas now session. God save the Constitution and the flag.
Please be seated. Good afternoon. We have one case on the docket. Herbert Briscoe versus the State of Texas. Is attorney for Mr. Briscoe here?
Present, Judge. Carmen Rowe for Mr. Briscoe.
And how much time would you like for rebuttal?
Judge, 5 minutes, please.
Okay. And for the state?
Yes, Your Honor. Ryan Kent for the State of Texas, appellate.
We have read your briefs and we have resorted to bringing the rule book with us, so we're finding it a little more complicated than we anticipated, so we're looking forward to your arguments.
Thank you, Judge.
May it please the court. This case represents a request by the state under so-called catalyst theory to push concurrent causation instructions beyond the bounds of well-established case law. The best and only case that they offer this court is this court's opinion in Ryder, which is clearly distinguishable and, if anything, furthers the appellant's argument that there are limits to concurrent causation instructions. While it's true that concurrent causation is given under the most minimalist standard, this case is an outlier. There simply is no concurrent causation here. Either appellant shot the single gunshot wound that killed the complainant or someone else did. Under either theory, and consistent with the case law, he was not the but-for cause of Latham's death in this case. He was either the cause or he was not, which the state had to prove beyond a reasonable doubt in this case. For this reason, I will instead focus on the factors that show some harm was present here, keeping in mind that any harm, regardless of degree, is sufficient to require reversal in this case. In this case, there's 3 areas to focus on. One is the state's closing argument, which was the last area of argument that the jurors heard before deliberating. 2 is that there were not 1, but 2 jury notes sent out addressing the state's argument. And 3, the trial court's concerns expressed on this record that allowing the concurrent causation instruction lessened the state's burden at trial. The state concedes additionally that even though the jury found him guilty of the lesser included offense, in this case of aggravated assault with a deadly weapon and not murder, that the instruction on concurrent causation wasn't limited to just the murder charge.
Well, we did have a question about that because it seems to be limited to the murder charge, and even when the state concedes, we still have to agree with them that they correctly conceded. So explain to us how the instruction applies to the aggravated assault also.
I think that the concurrent causation instruction, as argued by trial counsel, was misleading and confusing to this jury. I think that's made clear in the 2 notes that came back from the jury, having trouble applying that paragraph, as well as the other 3 areas of possible murder conviction. The jury clearly rejected the murder offenses, all 3. So all they were left with is what they asked the question about, which specifically was, does the verbiage by shooting at Keon Lameth mean specifically shooting at the individual, or does shooting towards the individuals with an S general direction? To which the court referred them back to the charge.
Yeah, but how does that question implicate the concurrent causation instruction?
I think,
as opposed to just the murder?
Of course, and Justice Jewell, I think that's a great question. Obviously, a lot of times we're left to speculate about what a jury does in deliberations and coming to their conclusions. So in this case, we only know what their questions were, which was they were asking for instructions in applying, the elements of the offense and finding him guilty. Soon after these 2 notes came out, they found him guilty of the lesser included offense of aggravated assault with a deadly weapon. I think that the concurrent causation instruction, in combination with the state's argument that Mr. Briscoe was guilty of murder, even if he did not shoot Mr. Lameth, is sufficient in combination with these questions from the jury to suggest that concurrent causation was a concern, was considered, and wasn't ultimately able to be reconciled.
So is that state argument always wrong? I was looking at some of the law of parties instructions, and there's one that appears to be correct, because I thought to myself, well, is that a legally incorrect argument to begin with,
Yes,
right?
Judge.
And it seems like under 702A1, you could kind of shoehorn it in there. That if you, acting with the requisite intent, cause someone else to do the shooting. So, was his starting the gunfight making the other person shoot? What's your theory? What is your position on that? Is the state's argument just legally wrong under any theory?
Judge, I would argue two things. One, I don't know that the facts in this case are so clear that he was the first shooter in this, what the state refers to as a shootout. What we know is that we have a video, that it's not clear who's there and who's acting, except that we know Mr. Briscoe discharged a firearm at some point during the shootout. As to the second issue, I think that the trial court judge, which is a veteran trial judge of 30 years, made clear that the concurrent causation instruction in combination with that argument was of concern in lessening the state's burden, that they were trying to find another way for this jury to find Mr. Briscoe guilty of murder. And so perhaps that argument would have been proper in some other area of the penal code or the code of criminal procedure, but in this case, the combination of the erroneous instruction on concurrent causation is the issue.
Can I follow up with the chief's first question? So, in the charge, the application paragraph
Yes, Judge.
on the concurrent cause specifically mentions the death of Lamoth, and so is it your position that that language nonetheless applies to the aggravated assault as well, in addition to the murder charge?
Again, Judge, yes, I think that
Okay.
this jury was charged generally on concurrent causation. And in this record, the trial court and the parties all discussed whether this would apply to the entire charge. And I think that it did, and I think the jury is instructed to apply each of those paragraphs. But again, going back to the jury's notes in this case, I think they were having trouble with the state's argument in combination with the law that they were given. And when they asked this question, trying to reconcile the facts as well as the law that was provided to them, again, the court referred them back to the charge generally.
So are you familiar with the new CCA case of Cyr, C-Y-R? That's talking about concurrent causation? It just came out. Well, it's a 2022, I saw. December.
No, Judge. Okay. But if I may, I would supplement, if it's appropriate, if this court believes that that may impact the ultimate outcome in this case.
The trial court did not have the benefit of that case, and I think it's substantially changes the analysis.
I see, Judge. Well, I'll definitely supplement.
All right.
But the cases that we're relying on are Court of Criminal Appeals cases in Robbins, as well as a case from this court in Fish that made clear that if an additional cause other than the defendant's conduct is clearly sufficient here, that's the intentional conduct of an unknown bystander by itself can produce the result, and the defendant's conduct by itself as clearly insufficient, which is set out in the indictment that was presented to this jury, then the defendant cannot be convicted. And I think that this case turns on whether or not there's a but-for cause, and that's what Robbins and Fish and some of the other concurrent causation cases talk about specifically. In this case, as I said, I think the facts are limited in placing Mr. Briscoe at the scene beyond being part of a shootout. Whether or not he's the first shooter, these were all facts that the jury could consider, but they were heavily contested in this case. And as I understand it, and as I viewed it, the video makes it difficult to know who's who, what's what, and who the first shooter might be, much less who shot Mr. Lameth. I mean, at the end of the day, there was no evidence as to who shot Mr. Lameth. What we know is that there were 5 identified people, among others that were unidentified, at the scene that night. And the only reason we know who the 5 are is because they went to the hospital. There were 3 people shot, there were 2 weapons at the scene, and 2 different caliber of bullets at the scene. We don't know much more, and as we stand here today in the Court of Appeals, we may know even less about what happened out there that night. The state argues that the catalyst theory, which is a domino effect theory and refers to the shootout, is sufficient in this case. There's no case on point that suggests that that has been applied in this manner. And again, the record reveals that there was a lot of concern about applying it here. On these facts, I think Ryder, as the state relies upon, is simply not persuasive. In that case, this court's analysis made very clear that the cause itself should be our focus. And again, here we do not have a but-for cause with this shooting. And because the facts don't raise this issue, it was error to give it to the jury. And we would suggest that we've shown some harm both in our briefing and here today. And I'll reserve the rest of my time for rebuttal.
Thank you. So, is the state familiar with the new CCA opinion?
The state is, Your Honor.
Okay, I'll give you the, if you have a pen, I'll give you the site now. Now that you've had a chance to sit down.
Yes, and the site is 2022 Westlaw 178-25857. So what I want to do, and may it please the court, and thank you very much for the opportunity to address this issue before you all. I want to address the evidence in this case because I feel that the recitation of what the record shows, and in particular what the video shows, this is State's Exhibit 6, it's the enhanced video, doesn't lead anywhere near to the ambiguity that opposing counsel suggests infects this case. What you see on the video, and what I hope your honors will consult when you're assessing harm, if you get to that point in this case, is you see a group of individuals circled in green. This is roughly at 5 minutes into the video. This group of individuals includes the soon-to-be deceased Kion Lamoth. It includes the survivor of the shooting, Marvin Hart, and it includes a third individual, a friend of theirs, who only goes by a sobriquet of Smash. They walk past a car that Mr. Briscoe, who is circled in blue, has been getting into and out of during the early parts of the video. And as they walk somewhat out of frame, Mr. Briscoe gets out of the vehicle, he raises his arm, and you can see the flash of the muzzle of his gun as he shoots at Mr. Lamoth and Mr. Hart. And Mr. Hart is shot, he survives, Mr. Lamoth is shot, and he dies. On the upper right corner of the video, you'll see a figure circled in yellow. This is the bystander. This is what the state at trial imagined to be a concurrent cause, though the instruction given doesn't specify what the so-called concurrent cause is. And that's relevant. It's relevant for addressing what could be a problem, which is the CCA's decision in Otto v. State from 2008. But what you see is the bystander 3 seconds after Mr. Briscoe starts to shoot at Mr. Lamoth and Mr. Hart, the bystander begins to shoot at Mr. Briscoe. And I believe counsel said something to the effect of so-called shootout, or it's me characterizing it as a shootout. It is a bona fide shootout that is precipitated by Mr. Briscoe and engaged in by the bystander whose identity is never discovered by the police. And that there is no case on point is a stunning proposition of law. We can go back 123 years to Keaton v. State, where a group of train robbers, used to be a thing, tried to rob a train. They grabbed a brakeman to use him as a human shield, and officers aboard the train, could have even been bystanders, I guess, in that era in Texas, or even today, started shooting at the robbers, and they struck and killed the human shield brakeman. And way back in 1900, Texas judges didn't have any trouble recognizing that it was the robbers who were responsible for the death of the brakeman. And that trend continues through to the 70s and the 80s in the cases of Blancett and Dowden, which are the infamous case of a group of ne'er-do-wells trying to break out one of their own from the local jail. And in the midst of this operation on their part, a police captain is shot and killed, not by Blancett, not by Dowden, but by one of the officers.
But that is under 702A1. It's not under concurrent causation.
Well, Chief Justice Christopher, I would suggest
Because
that
I read Blancett.
the opinion in Dowden does not rest its finding that Dowden was responsible for Captain Gray's death on the basis of law of parties, because there was no vision of those facts that says the officer, Gray, who shoots and kills the captain, was acting in cahoots with Dowden or Blancett or anyone else. So it's not a combination theory. I think that word shows up in the reply. It is instead that, and the CCA discusses what they're basing this vision of Texas law on. They're taking quite heavily from People v. Gilbert, California law, and its conception of causation and criminal culpability, and that envisioned within 604, our own statement of causation, is the notion that one is responsible for the knock-on effects of their bad conduct. And there were things said at this lectern previously about Mr. Briscoe is not the but-for cause of Mr. Lamothe's death. He absolutely is. He absolutely is, because he precipitates the shootout. The state argued, and I think the evidence is rather persuasive, that it was Mr. Briscoe who shot Mr. Lamothe. But even if one wants to imagine that it was the bystander who did, the bystander is only discharging his firearm because Mr. Briscoe is shooting at Mr. Lamothe. And if it happened to be, admittedly, the ballistics will not tell us that it was a .45 caliber, that being the type of gun that Mr. Briscoe was wielding, won't tell you that that was the type of caliber that killed Mr. Lamothe.
But if the concurrent cause is wrong under Sear, where does that leave you?
Well, it leaves the conviction undisturbed, because even if it was a mistake to give the instruction, and I suggest we can walk through, the brief does so, but I'm happy to do so, the analogy between this court's opinion in Ryder and the facts of this case, but accepting, for the sake of argument, that it wasn't a proper instruction, the Almanza analysis cannot possibly produce a conclusion that Mr. Briscoe was harmed.
So in the charge, what y'all have is basically the concurrent causation. We're not talking about something in the case law that gets you where we're just arguing. This is the concurrent causation argument.
Sure.
Okay, which is page 119 of the clerk's record. So, all right.
Well,
Is there another part of the charge that gets you? I mean, if that goes under Sear, is there another part of the charge that saves you?
What saves us is the fact that the cases that I mentioned, Keaton, Dowden, this own court's opinion in Longoria, home invasion, robbers of the home, precipitate a shootout, officers respond, an officer is shot and killed by another officer. None of that dealt with concurrent causation. It was just plain as could be, based on long-standing Texas law, that Longoria was responsible.
Did it have to be in the charge?
It did not have to be in the charge. That is the through-line concept of causation, or that is the notion of causation that pervades Texas law. We have a liberal, not in the political sense, but in the sense of the word has a broader meaning in Texas than it does in places like California and in Maine and other jurisdictions. We have a very liberal standard when it comes to a person's responsibility as a causal force for the ill effects that happen in the world. And our 604 concurrent causation statute, subsection A, gives a very narrow window in which a wrongdoer can escape culpability, and that's the clearly insufficient language, the unless clause in the statute. But if you never instructed the jury on concurrent causation, they can still, as Longoria from this court shows, as Dowden shows, as many other cases show, they can still come back with a fully supported verdict of guilty.
Sure, but by giving the concurrent causation, have you lessened the culpable act or mental act that the state has to prove?
Not at all. What we have done in giving the instruction, and again, assuming that it is an erroneous instruction, and if it is erroneous, it's only erroneous in a semantic sense. It's only erroneous in the sense that calling the bystander a concurrent cause is a misnomer. He is instead just the intermediate domino that is set off by Mr. Briscoe, the primary domino, that led to the death of Mr. Lamothe. All that instruction does in misnaming the bystander as a concurrent cause is it gives Mr. Briscoe something of an escape hatch, one that he could never hope to climb through, which was there evidence in the record, is there evidence at trial for the jury to say that my conduct was clearly insufficient to bring about the result. In this instance, the result is Mr. Lamothe's death. And there's no one who can watch that video and come away from it thinking, well, this clearly shows Mr. Briscoe is an insufficient force in this combination of forces to produce Mr. Lamothe's death. He is fully sufficient because if it was the bystander who killed Mr. Lamothe, it is only by dint of Mr. Briscoe starting the shootout. So that's all the instruction does. I mean, it's commented in the reply that the state argues in our original brief that the instruction benefited Mr. Briscoe. That argument is not actually made in the state's brief, though I'll make it here that all the instructions served to do was to give a very narrow window of opportunity for Mr. Briscoe to escape culpability on the misunderstanding that the bystander was a concurrent cause.
What do you make of the jury's note by shooting at Keon? Does that mean specifically shooting at the individual or just shooting toward the individual's general direction? What do you make of that note?
I make almost nothing of it because it has nothing to do with concurrent causation. Justice Jewell is absolutely correct that it is focused on the dangerous act element of the felony murder paragraph and you could have that same question come from the jury irrespective of whether you gave them a proper or erroneous concurrent causation question. They're trying to understand, without any direction from the trial court, correctly so, they're trying to understand what is being asked of them to find. Are they being asked to find that Mr. Briscoe was aiming at Mr. Lamothe, or are they being asked to find that he was simply shooting in the direction of Mr. Lamothe, and that may have been the thing that hung them up and led them to a verdict on a lesser included, rather than the verdict of felony murder or just plain murder that the state urged. That is, they may have disagreed among themselves that what needed to be shown was this intention by Mr. Briscoe to shoot as if in a bullseye at Mr. Lamothe versus maybe he was only intending to shoot Mr. Hart but wound up shooting Mr. Lamothe as well. That is all that I make of the instruction, is as some kind of insight into what may have led the jury to come out with the verdict that they did. But does it bear on the concurrent causation analysis and whether the instruction in any way harmed Mr. Briscoe? No. The Almanza analysis shows us that there was no harm here. There was an argument, certainly to be made based on Ryder v. State, that the instruction was correct. And if you want to step away from that and deal with the 4 parts of Almanza, the instruction, quite unlike in Otto v. State, says nothing about what is the concurrent cause here. It's rather nebulous what it is saying is the concurrent cause. One questions whether the jury even gave it much thought to begin with. The rest of the charge was correct. The state's arguments, this is the 3rd prong of Almanza, the state's arguments were correct. Like I say, it's a semantic difference between whether the bystander's a concurrent cause or a downstream cause of Mr. Briscoe's misconduct. And the evidence at trial, that 2nd prong of Almanza, is overwhelming that Mr. Briscoe is culpable. The nature of the evidence here puts correctly the onus on Mr. Briscoe for all of the injuries that befell the people in that parking lot, including his own, because he's the one who is ostensibly shot by the bystander. All of that is on Mr. Briscoe's shoulders as the first shooter, the instigator of the shootout.
So to the question about everything else in the charge being correct, on the aggravated assault, is the only way that can be proven, the way this was given to the jury, is if someone dies in this case?
I don't think it's the only way, because if I'm not mistaken, the fact that an individual died perforce shows that they suffered serious bodily injury. That the fact that the individual died by a gunshot wound, of course, perforce shows that a deadly weapon was involved. I reckon that they could have, even without the tragic death of Mr. Lamothe.
But you couldn't threaten somebody under the facts of this case. You'd actually have to cause the injury.
Well, sure. The facts of this case reveal an actual injury inflicted. I mean, that is, in fact, one of the 2 ways in which the lesser included of ag assault was defined for the jury.
I'm just wondering the way the jury asked the question, if they were shooting in the general direction and didn't get there, you actually, in this case, the way it's charged, you have to have somebody actually die or be seriously injured.
That may be so, and rather regrettably, that's true in this case, that someone did die. And I think, again, the jury's question just goes to this rather, I believe, picayune point on their part as to whether Mr. Briscoe had Mr. Lamothe in his crosshairs or not. I don't think that would make a difference in an aggravated assault prosecution, that he would still be responsible for having intended to shoot in that direction and wound up shooting Mr. Lamothe. But this is, in some sense, rather beside the point, because the instruction didn't bear on concurrent causation and doesn't reflect anything of the jury's fixation on the issue. And again, even if they had fixated on the issue, the evidence is overwhelming. The focus, such as it was during the closing arguments, was non-existent practically. The only way that the opposing counsel could conjure up that it was featured in closing argument was a vague passing reference by the prosecutor that Mr. Briscoe was responsible because of this. That's all the record says. The prosecutor, if she may have been wrong about saying it was concurrent causation that made him responsible, she wasn't wrong in substance because he fully was responsible. The verdict was correct, and we would ask that the court, if there are no further questions, the court to affirm the conviction.
Well, let me just, one more question. So, would the verdict be correct if there had been no law of party instruction at all? If the concurrent cause was gone and there was nothing from 702 given to the jury, would the verdict have been correct?
Well, just to clarify, I do not believe that there is any instruction. Of course, the concurrent causation instruction comes from 604 Penal Code. There is no law of parties instruction given because that was.
So I'm asking you, assume that 604 was removed from this jury charge. Could a jury convict under your domino theory?
Yes.
Without anything further?
Absolutely. Though I don't know if it's mentioned in Dowden, I'm not sure if it's mentioned in Longoria. I do not believe those cases, to the extent they talk about upstream, downstream, you're responsible for the downstream effects, in any way base that on an instruction that was given regarding concurrent causation. I'm nearly certain of that, that those cases don't even feature discussion.
Well, I know Blancett, for example, talks about the instruction in 702A1.
It does, but that's partly because Blancett is a case that inextricably involves parties. That's why it would be roughly 10 years later when Dowden was convicted of the same crime, because there were people acting in cahoots in that case. This is not a case. Longoria may have talked about law of parties, and in fact I'm sure that it does, because part of the issues in Longoria was that Longoria wasn't one of the ones in the firefight. He may have been the driver, he may have been the planner. But that's not related to concurrent causation. That's related to the culpability that you shoulder as a party to an offense, even if you don't have the gun in your hand, so to speak. That's a different issue when there are multiple conspiring or working in cahoots actors.
No, I'm just talking about one guy shoots, the police shoot back, and they kill somebody else. The police kill someone.
Sure.
You could charge the defendant, the person who started the shooting, and the cop shoots back with the murder. But would you need an instruction in the jury charge other than just murder?
You would not. You would not need law of parties, and at least if you follow some of the musings on concurrent causation from Blancett and Dowden, you wouldn't even need a concurrent causation instruction. The basis for giving instruction in this instance is this court's own binding precedent commentary in Ryder that very plainly says that in an upstream, downstream, catalytic type fact pattern, it is proper to call the upstream and downstream causes concurrent causes. This is on page 451. That's the pin site in Ryder. You can find the section of the opinion.
It's such a different fact scenario than this one, though.
Well,
Ryder, and we still have the Sear case since then.
We do.
It says basically you shouldn't give it.
Sure. I don't want to overstay my welcome, but I'm happy to respond on the point on Sear.
Yes, please.
So I can make it brief. Sear is talking about the different situation when it is the defense who is seeking the instruction. And as we know, the defense has to have a particular quantum of evidence toward the elements that go towards the defensive theory. It's a small quantum, but still something, in order for them to be entitled to the instruction. And what Sear was saying is there was nothing in these facts that go towards your conduct, Sear, was clearly insufficient to have caused the injuries in this instance, which were horrific injuries to a child. So it was about the failure of the defense to satisfy its burden to get the instruction included in the charge. And it doesn't, I mean, I don't think that it's terribly important for this case, even if at the end of the day, what matters in this case is the harm that Mr. Briscoe suffered, which, as I've said, and will say again, is zero. And with that, I would ask the court to affirm, and thank you again for your time.
Thank you.
May it please the court. The state, in its reply as well as here today, keeps saying how plain this case is, how simple, how overwhelming the evidence is. Well, again, this jury rejected their claim, both in their brief and here today, that he's guilty of a murder. They found him guilty of the lesser included offense of aggravated assault. And I would add to that, in our first issue, there was an amendment pre-trial where this jury heard that Mr. Briscoe shot at Hart, who was also in that parking lot, that his caliber gun was the gun that Mr. Hart sustained the injury by, as well as the fact that there was DNA that connected him to that gun. The problem here is, and I think Chief Justice Christopher mentioned it, is that they didn't have any of that evidence as regards any intent, any motive for him to shoot at Mr. Lameth, who's the complainant in this murder. So mid-trial, this jury no longer hears about Hart, but they've heard about him through half of the trial, again because of concerns by the trial court that this might have been improper from the beginning, but at some point it was. And so then they get to the jury charge, and that's why their note is so important. And the fact that the state needed the concurrent causation instruction in this case, I think is compelling evidence of some harm, which is a lower standard than other types of harm. And in this particular case, I think that there's plenty of it in the record.
So what do you think about the state's argument that if concurrent causation was just absent from the charge, they still could have gotten their conviction?
Well, again, there are arguments today that there's overwhelming evidence and that he's still guilty of murder. That's simply not true. That's not what this record suggests, and it doesn't look like what this jury was trying to reconcile. They were trying to figure out if he shot Hart with his gun in that parking lot, did he more likely than not also shoot Mr. Lameth? And if we can get there, we can find him guilty of aggravated assault with a deadly weapon, which is the most the state could get on this murder trial. And I think that's compelling evidence of harm. But in addition, back to the Almanza factors, I think the most compelling is the state's argument that this was a domino effect, that this catalyst theory was real, that this jury could find Mr. Briscoe guilty if they only believed he shot a weapon inside of a shootout in a parking lot, which they know he did because they know he shot Mr. Hart. So that, to me, in combination with their two jury notes expressing confusion about the shootout, about what the state had to prove beyond a reasonable doubt in this case, and finding him guilty, was important because it's whether he was intentionally shooting at Mr. Lameth or whether he was just shooting into the parking lot and Mr. Lameth died, knowing that there was at least one other shooter in that same parking lot. But I also think that as regards some harm, the trial court's expression on the record, going back and forth with the state, who did not provide a compelling argument for getting the concurrent causation instruction, is telling. Because this veteran trial judge understood that it lessened the state's burden, which is exactly what I think it did in this case. And so I would disagree respectfully with the state that without that instruction—
Lessen the state's burden as to both of the charged offenses?
Yes, absolutely, Judge. And they had that burden lessened according to what the trial court had concerns about. I think it's clear that that happened here. I think that the notes suggest as much. And the fact that after all of this and all the chaos and all the confusion of the shootout, the jury could only come back with an aggravated assault, deadly weapon, lesser included offense. And I think it goes directly to the note that they sent out expressing concerns about whether they could believe what the state told them in closing arguments. If you believe that Mr. Briscoe shot into that parking lot, you can find him guilty of murder. And I think they struggled with that. They didn't find him guilty of murder, but they found him guilty of an aggravated assault, which was consistent with what they already knew, which is that his gun shot Mr. Hart, who survived, in that same parking lot. For all these reasons, we would ask this court to remand for a new trial consistent with its opinion. Thank you.
Thank you for your arguments today. The case of Briscoe versus the State of Texas is submitted, and we are adjourned.
All rise.